Hello, everyone. Welcome to today's program, Patent Litigation Defense in the Trenches, Venue, Local Rules, and the Defense Playbook. I'm Ala Policastro, Director of Education and Professional Development at BHBA. And now I'm delighted to introduce our speaker for this program, Karen Boyd. Karen is a partner in the Intellectual Property and Technology Litigation Group at Thompson Hine, where she represents clients in patent and other intellectual property disputes. Her clients have ranged from solo inventors and universities to Fortune 100 companies in technologies spanning pharmaceuticals, consumer electronics, and medical devices. Karen clerked in the U.S. Court of Appeals for the Federal Circuit and went on to teach patent law at UC Berkeley and UC Law San Francisco. She also serves as a mediator and arbitrator in IP disputes and sits on the mediation panel for the Northern District of California. For more than a decade, she has been recognized by California Super Lawyers and Best Lawyers, including as the Best Lawyers Trade Secret Law Lawyer of the Year in San Francisco. We're so excited to hear what she has to share with us today, so I'm now going to turn it over to her.
Thanks so much, Ala. Let's see, I'm going to try and start sharing my screen. We tested this ahead of time, so hopefully I've got that correct. It's great to be here today. And of course, because we're all lawyers, the very first thing that I need to do is well, let's figure out how to do my screens. Why is my next slide coming? So we have our standard disclaimer about this presentation not creating an attorney-client relationship and being my thoughts and not necessarily my clients or my firm's thoughts. But sort of off the bat, what I wanted to do is you've heard a little bit about who I am. You can see behind me sort of my technical background. I'm a biologist by a long time ago. Those are very old DNA fingerprinting technology. Those are actually my two children behind me on the screen. But I wanted to find out a little bit about who is attending today. So I have three polls on demographics that I'd be interested in seeing your responses. One is how much of your practice is patent litigation focused. So I've called that the "How big a nerd are you?" Poll. So basically everything you do is patent related. That's where I am. You're pretty nerdy. You actually can go to a party and comport yourself with normal human beings. So some patents, but not a lot. Or you signed up for this particular webinar on accident and you thought patents was about shiny leather shoes. The second question that I have for you is what side of the V do you tend to live on? This particular presentation is very much defense focused. My practice in the non-practicing entity or patent troll space in the vernacular, I am defense side on that. And then I also in competitor litigation, I am actually very evenly split between defense and plaintiff side. So this is a question that kind of goes to that. And then the third question that I have for you that you can scroll, I think you'll need to scroll down to it, is just how senior you are, how long you've been practicing law. So anything from, I still remember my high school locker combination, so a very, very junior lawyer, to I practiced law before there were Post-it notes for the very senior lawyers. Post-it notes were released, if you want to know, in 1983. So that's the cutoff for the Post-it note reference. Do we have the results of those polls? Okay, so looks like evenly split, pretty evenly split along how much patent stuff everybody does. We have 25% all the way nerd, and 38% thinking that patents are about shiny leather shoes. Depends on the case is the predominant answer for which side of the V are you on. So some people, 30% on the defense side, 15% here spying. They typically represent plaintiffs, and then most, almost 60%, depends on the case. We have mostly, let's see, mostly people in the sort of mid-career, 5 to 10 years, a couple in 10 to 20, a few in the 20 to 50 years, which is where I land. Nobody who practiced patent law before there were post-it notes, and I would be just very interested to understand how that happened. I use post-it notes every single day. So, all right. So thank you for responding to those questions. So what we're going to be talking about today, and I really want to encourage everyone to take advantage of the Q&A feature. Any questions you have, any comments you have, despite the webinar format, I would like to make this as interactive as possible. So the Q&A field is how we're able to do that. And I'm going to keep the Q&A off to my side here, but try and keep one eye on it. And also people from the Bar Association are monitoring that as well. So what we want to talk about is how you can use case management and sort of procedural things to drive patent cases, and especially what you should be considering as on the defense side in patent cases. Some of this is some of these slides, which I know you've already gotten a link to in the chat, and these will be available after. There are some resources embedded in these slides that I'll highlight when we get to certain of those. At the end, if we have some time, there is another sort of a bonus topic, which is 1782 discovery, which is a highly procedural a discovery option that we have in the United States, but to support litigation that's happening elsewhere in the world. So it's something that we are seeing more and more in our practice, especially as our practice becomes and our clients have more and more international and multinational patent litigation issues. So that's kind of a bonus procedural issue that we will get to if we can. If we aren't able to get to it, then you have some slides about it, and I'll encourage you to take a look at that when you have the opportunity, because it really is a pretty nifty tool to support litigation that's happening outside the United States. So case management is something that I love. I think it's something that often gets sort of pushed off to the side. You get a new case, you want to dive into the patents, you want to dive into the technology. Somebody goes and dives into the damages, but a lot of us really nerdy people want to stay in the technology. We want to look at infringement. We want to look at invalidity. So case management sometimes takes a back seat, and I think that's a real lost opportunity. There are reasons for it. The being interested in the substantive issues, really being pulled into those, not wanting to deal with opposing counsel. Opposing counsel can be a pain. So there are reasons that case management sometimes takes a back seat, but it's an opportunity that we should all take. We should be thinking about big picture strategy in our case very early on, and how does case management drive that big picture strategy? You can actually move the needle on substantive issues if you are using case management and procedures in their highest and best form, and we'll get to some examples of that later. And the way that case management can affect your case spans the entire life of the case, everything from your very initial opportunities for management with the court, all the way through trial and post-trial and into appeals. So there are opportunities for case management in in all cases through initial disclosures, your case management conference, protective order issues, when you do summary judgments and how you do summary judgments, Daubert motions in connection with your experts, your pretrial conference, those happen in every case. Specifically for patent cases, there are issues around case management that are driven from patent local rules, technical issues of our production of technical documents. We'll talk about source code for a minute coming up. And claim construction, of course, the big daddy since I guess it's in 1995. So just before I started practicing law is when the Markman case, I believe, came out. So my entire practice, we've had these things, claim construction hearings or Markman hearings. Those didn't always exist before the mid-90s. And issues around bifurcation and especially willfulness or damages bifurcation issues are very common in patent cases, or we should commonly be thinking about them, even if they aren't very common. One thing that I want to highlight for all of this case management is getting your client involved. It is tempting because you can kind of do case management in a check the box kind of way to not really involve your client, but it's an opportunity to talk to your client about the big picture issues, and also sort of what the client can expect, especially if you're representing a client. If you're representing a client that has patent litigation all the time and they have dedicated in-house litigators who know exactly what's going on, it's less important there. But when you have the clients who are they're lucky enough to have not had a lot of patent litigation experience, case management is an opportunity that you have to really sort of teach them and explain to them what they can expect over the case. Something that I tend to joke with when my client representative is not a lawyer, I will, of course, those clients are clients that you have to explain, in a lot more detail and sort of starting from the beginning. And I joke with those lawyers that I'm gonna convince them to go to law school by the time the case is over. They always laugh. Nobody's ever actually gone to law school, but maybe sometime in the future. So let's talk about initial things, initial disclosures. These happen in every case. You give the names of your witnesses, you give a list of, where your documents are, you have damages, computations, which typically you say, we don't know yet. In certain districts, including in the Northern District of California, there are some damages contentions that happen early on, but not quite as early as initial disclosures, insurance information. The thing about initial disclosures is really knowing the judge that you're in front of. There are a couple of judges in particular who have different requirements for your initial disclosures. Judge Connolly in the District of Delaware requires the disclosure of third-party litigation funding. That is something that has been a very big thing in his court. And so that's something to be aware of. Judge Alsup in the Northern District of California, I would say, is also someone that you want to know his particular views if you are in front of him. You need to do a really good job in thinking about who the witnesses are on your initial disclosures, and you need to keep on top of your initial disclosures if somebody else comes to your attention. Because with Judge Alsup, if you get to trial and you want to bring somebody to trial who wasn't in your initial disclosures, even if they were in a supplemental initial disclosure, you're going to have to explain why that person wasn't on your first initial disclosure. So it takes the obligations of the initial disclosure requirements of Rule 26 very, very seriously. Your initial CMC and your CMC statement that you negotiate with your opposing counsel. This is an opportunity to lay out the case for the court, and we have a lot of structure that's driven by the rules. But take the opportunity to be thoughtful about it. And there are a few places in your initial CMC that I think are particularly fertile ground for sort of moving the ball forward. Um, and that we've listed them here. Discovery limitations can be very highly negotiated. That can really sort of form the case going forward. One thing on discovery limitations to think about in many patent cases, source code review can be a big, expensive, complicated, dangerous thing for our big high-tech clients. And there are a lot of patent cases where early on, depending on the style of patent claim, if it's a patent claim that doesn't really need source code, you may be able to get an agreement to that effect early on. And that's something that I think people should try to take advantage of, because if you can get a stake in the ground in your initial CMC that source code review isn't going to be necessary, that can streamline your protective order, it can streamline discovery in very important ways. Another thing that is invited in initial CMCs is case and claim narrowing. Some judges require that, require the parties to talk about that and to have a proposal. But I think any judge would welcome it. So if that's something that you want to try and propose, having those proposals early on can be kind of a less fraught time to bring up those kinds of issues. I want to talk about venue for a minute. This, of course, is an issue that um, uh, many full-length CLEs have been done on patent venue. Venue is a little bit more settled now than it was for a long time, but it also continues to evolve. So whenever you are representing a domestic entity, if you're representing an international entity, they can be sued anywhere in the United States as far as the venue provision. So you're just looking at jurisdiction there, personal jurisdiction there. But if you're representing a U.S. company or a U.S. entity, always look at whether venue is proper. Maybe it's a reach. There was just last week there was a venue decision in the Eastern District of Texas where Apple was sued in the Eastern District of Texas. The venue arguments that were made had to do not with Apple stores in the Eastern District, because Apple closed all of its Apple stores in the Eastern District of Texas in 2019. But they have Apple shops inside of Targets and inside of Best Buys. And they also have employees, Apple employees, who live in the Eastern District of Texas. So there was a case just last week that came down that found that that was not sufficient for there to be venue. They did transfer the case, but it's still something worth thinking about. I will flag an issue that I have seen. I haven't seen it in the courts yet, but the question of what happens if somebody is in the process of building a manufacturing facility in a venue. Is that enough to get you venue, or does the manufacturing facility have to be up and running? That is one of the open issues in venue. There are also evolving views on remote workers and how remote workers are considered for venue analysis. Don't forget good old forum nonconveniens now, 28 USC 1404. This is if you want to be in a different district than where you have been sued, you can get transfers on convenience if you've got good arguments, including if you've been sued in Delaware and you would rather be rather than where you're incorporated, where your headquarters is, you can still get a transfer out of Delaware if the factors are for a transfer for convenience fall in your favor. So don't give up hope if you are representing a Delaware corporation in Delaware. You can win that motion. You don't always, but you can win it. Okay, so once you've figured out what the venue is, where does that take you? So venues, obviously, are there about what do the juries look like ultimately at the very end? What do the juries look like? But there's a lot of stuff that happens before you get to jury trial. Local rules, patent local rules, standing orders. I have a handy dandy little map that shows all of the different options for patent local rules specifically. All of the states in orange or the districts in orange here have no local rules or judge-specific standing orders for patent cases. The states shown in green, they have patent local rules. The states shown in purple, or the districts shown in purple, have judge-specific patent uh, judge-specific standing orders for patent cases for at least some of the judges. And the sort of deep blue districts are where there are both patent local rules and judge-specific standing orders. So this is an area where we have just sort of some resources here. These are all of the districts where there are no local rules or standing orders related to patents. I've included on here Arizona and Oregon. Technically, they have their local rules do mention patents, but it's not substantive as far as they're more sort of you have to disclose that there's a patent involved, that sort of thing. These are actually live links for all of the patent local rules for each of these districts. So, a resource for the future. Sometimes the patent local rules are a separate set of rules in the Northern District of California, which I believe was the first district to have patent case-specific local rules. They are separate rules. But in a lot of these districts, it's actually a section within their civil local rules. So these are links to wherever the patent local rules are, these are links to those. Likewise, oh, actually, I want to go back 2 slides because I had a question. I will invite anyone who knows what DN Mar I is, what district that is. I will invite that into the Q&A for anyone who knows what district that is. And then these are specific judges within certain districts that have standing orders where these districts don't otherwise have patent local rules. And so those, again, are live links to those. And then our final category where there are both patent local rules and there are standing orders for particular judges. I haven't tried to put all of the links in for this. I will just, if you are in one of these districts, and frankly, these are the districts where we have, the vast majority of patent litigation occurs in these districts. We have, you have to look at the particular judge you're with. You have to look at the rules and how your judge's standing orders interfaces with the patent local rules. I will flag one issue that comes up, and especially this seems to come up in Delaware more than elsewhere. But sometimes you have a district judge and you have a magistrate judge, and their standing orders aren't the same on various issues that relate to patents or other procedures. So you need to tread lightly, you need to ask questions, you need to know who a particular issue is going to, so you have to know whose rules you are following. And this is an opportunity, remember those slides about case management conference statements. Case management conferences are one of the places where you can get clarity on who handles what and what rules apply to what. All right, so the next thing I want to talk about, we have Keeley Vega. Mariana Islands is the correct answer. It's the district. DN Mar I stands for the District of the Northern Mariana Islands. And actually, if we go back to this map, one thing that I noticed, all of our island courts So we have Puerto Rico, we have the Virgin Islands, we have Guam, we have Hawaii. You know, Alaska is not an island, but it always shows up on an island on maps. None of them have local patent local rules or judge-specific standing orders. So, what do we make of that? All right. The next thing that I wanted to talk about was anti-troll legislation. This is another thing that I think more people are starting to look at this. There was a whole wave of patent litigation that was targeting bad faith patent assertions. This started in 2013 in Vermont. There was sort of a wave of legislation, and uh, and it's because the wave of legislation about bad faith patent assertions sort of also was happening when a lot of the AIA opportunities were kind of coming online. I think we as patent defense people haven't taken advantage of the anti-troll legislation as much as we could have. I think in the uh, in with the limitations on the availabilities of IPRs, and it looks like the availabilities of EPRs going forward. I think that we may be seeing, there's all the more reason to sort of look at this anti-troll legislation, and if those give us some opportunities. I have another handy dandy map here that shows a few different things. The orange states are where there is currently no legislation in effect. The blue states are where there is legislation in effect and that it is either a private cause of action. So for our cases, where we are representing private entities, we have the opportunity to assert these kinds of claims. And then in the gray states, there is legislation that's on the books, but it is state attorney general enforcement only. So that we, as private attorneys, we don't have the opportunity to take advantage of those, but they do exist there on the books. I'm going to use as an example for the legislation the Idaho law, and the reason that I'm put the Idaho law up here is that there was a recent case. There's a current case where the Idaho bad faith patent assertion law is in play. Under the Idaho law, the way it's structured, and this is a very common way for these laws to be structured, this is how the original Vermont law in 2013 was structured. So it's basically, it prohibits bad faith patent assertion. There are multiple factors that are considered as to whether it was bad faith. There are also, this is on the next page, these continue to be the bad faith factors. And then there is a section on good faith factors and things that sort of are on the other side of the scale as to whether or not it was a bad faith patent assertion. Some other things about how these laws are structured, they tend to be integrated into the consumer protection laws of a state. And there are often exceptions, carve-outs. One common exception that's in most states where they have this kind of structure is a Hatch-Waxman exception, so an exception for generic drugs. And there's often also an exception for universities and other academic institutions. Some of these anti-troll legislation require a bond to be posted. And that actually is the issue that's in play in the Idaho case now. So I'll get to that in just a second. Alternative structure. So again, this is the original structure that Vermont came up with, that Idaho and many other states follow. There are some alternative structures, though. For instance, in Wisconsin, the law that is on the books basically requires demand letters, patent infringement demand letters, to have specific information that the Wisconsin legislature decided that would reduce the number of bad faith sort of holdups for patent cases. And in 4 states, Texas, Oklahoma, Montana, and Louisiana, the legislation that's on the books is really, really focused on demands that are made to end users. So sort of to customers who are are nominally direct infringers, where they are, you know, the real target as far as the patent is concerned is Apple, and the letters are being sent to consumers that are buying Apple products. So those 4 states, that's the particular kind of bad faith patent assertion that they are trying to target. All right. So what's going on in this? And again, these are laws that have been on the books for a good long time, but there hasn't been a lot of activity with them. But I think that may be changing again, because some of our other procedural options are waning right now. So a couple of cases. So the Valve Corp v. Rothschilds in Washington State, there was last month, there was a jury verdict against a patentee for making an assertion of patent infringement in bad faith. So that is something that case went all the way to trial. There was a jury verdict. I expect that will be appealed. We will be watching the Valve Corp v. Rothschild case for a while to see what happens with that Washington State anti-patent troll litigation. This is the Idaho case. Micron v. Longhorn IP is the Idaho case that I've mentioned a couple of times. So in Idaho, there is a bond that's required to be posted in the case of an assertion of the Idaho anti-bad faith patent assertion law. In some cases, there are other states where there is also a bond requirement, but there are some dollar limits on it. In Idaho, there is no dollar limit on it. And this court, the District of Idaho, there was some procedural stuff, but it ended up in the District of Idaho. That court required an $8 million bond. There was a challenge by the patent holder to the constitutionality of this legislation, asserting federal preemption. There was an interlocutory appeal made to the Federal Circuit, who dismissed that interlocutory appeal for lack of appellate jurisdiction. So this is a case where it's gone back down to the district court. It has, I believe they have just, that the district court has denied a motion to stay the case pending an IPR. And we have not gotten an answer to the question that I think a lot of us are wondering: will these laws survive a preemption challenge? So stay tuned on that, and let's bring some more of these. Let's try this legislation out as well. I think that's an opportunity that we should be considering. It can also be a very big settlement lever. Our firm has used anti-troll legislation, either a counterclaim or an independent claim, to drive settlements or withdrawals of patent claims. The problem, of course, when you drive a settlement is that you never do get to the answer of is there federal preemption. So, but there are tools. These are tools that we should be considering for our clients. Next, you sort of, again, back to procedure within a patent case, within, sort of the core patent infringement case. What are some things that drive decisions and what are decision-making points? Um, as far as how can you exit, how can you get your client out of this case? How can you drive substantive decisions that will dispose of the case? How can you drive substantive decisions that will drive a settlement of the case? And your schedule is important to all of this. So the Eastern District of Texas is a district where there are requirements for early disclosures of your technical information. The Western District of Texas under Judge Albright's uh, um, uh, order governing patent cases also has these early disclosure requirements. I've sort of taken Western District of Texas out of these slides because with Judge Albright's retirement, I believe at the end of next month, sort of what that district is going to look like is very much an open question. Um, but this early disclosure of technical documents is something that you see sort of through a lot of patent cases, a lot of patent rules, rather. Um, think about those patent local rules and how they will work for your case. And if there is a reason, a thoughtful, legitimate reason to change them, use the CMC opportunity to talk about that. Maybe you can get your opposing counsel to agree to it, especially early on. Sometimes opposing counsel can be more agreeable early in a case. And talk to the judge about it if you think that there is a real reason, and you can articulate a case management reason. Judge Tiger is always, for instance, in the Northern District of California, always very interested in case management, the best ways to manage cases on his docket. One of the things that he does is that his initial schedule in a patent case will only go through claim construction. You will not get a trial date from Judge Tiger right off the bat. What you'll get is all your dates through claim construction, and then you'll have another case management conference and you'll talk about the rest of the case from there. Looking at the judge that you are in front of, another judge that I've recently done some scheduling work in front of is Judge Noreka. Her practice has changed quite recently, and the orders that she is issuing now on schedules, your final contentions, your final infringement and invalidity contentions are after the close of fact discovery, but before the close of expert discovery. That has been where her practice has sort of shifted to. This leads to a practice tip, which is that judges' practices do change over time. Whether there is a standing order about schedule or not, I would encourage you to always go and look at the last few schedules that a court has issued, so that you can see what their in patent cases, so that you can see what their practices are. I think Docket Navigator is the easiest way to do that. I understand Lex Machina also has those kinds of resources, but use your favorite platform and look at what courts are actually up to. Case narrowing is something that is baked into some judges' standing orders, some districts' patent local rules, but it's this idea that over time, that a jury trial for a patent case can't be on 15 patents and 147 claims with 47 different prior art references and hundreds and hundreds of combinations. You can't try a case like that. So case narrowing is, how do you in a thoughtful way get to a triable case. And you can use case narrowing, whether it comes from the rules that have been set out by your judges. If it hasn't, and you think that you look at what's being asserted in the complaint or what's being asserted in infringement contentions, and you realize this is not a triable case as it's starting out, make these proposals. Judges like them. One thing that we don't have a lot of clarity on is what happens to the other patents that don't make the final cut, the other claims that don't make the final cut, the other prior art that doesn't make the final cut. Those are procedural questions that haven't been answered by the courts yet. So, oftentimes a narrowed case will then, if it goes to trial, will cause a settlement that sort of takes care of the rest of it, and that's why we don't get these questions answered. But we will maybe someday have that information about what really happens to those sort of dropped claims. Another place for some thoughtful case management related issues that just like butt right up against our substantive patent law issues are in claim construction. So there's lots of different rules that different judges have on claim construction. In the Northern District of California, you have to identify the 10 most important terms, but you still have to identify all the terms that are in dispute. How different districts handle experts varies from district to district. So you have to keep those in mind if you are in a district that has already developed claim construction procedures. And if you are not in a district with well-developed claim construction procedures, consider that an opportunity. That's an opportunity that you have as somebody, as people who do a lot of patent litigation, and maybe you're in a district where the judge doesn't have a lot of experience with patent litigation, where you can propose a way to approach claim construction that will sort of advantage your client or advantage the process. And you can mix and match. So, for instance, in the Northern District of Illinois, their patent local rules have a process where if the patentee is asserting that a claim element should be given its plain and ordinary meaning, what that does is it flips the order of the briefing in claim construction. So instead of our default, the patentee sort of does the first brief, and then the accused infringer responds, and then there's a reply, and sometimes there's a surreply. It flips that, and it says, well, if the patentee, it really makes a lot of sense. The patentee is saying that it's a plain and ordinary meaning. Patentee doesn't have much to say about that in an opening brief. So what we're going to do is have the defense speak first, because the defendant who is saying it needs a particular construction, it makes sense for them to give that position first. So that is a structure of the briefing that I have persuaded opposing counsel to adopt that, even in districts that do have claim construction orders. I've made that proposal to judges and had that approach adopted by judges as well. And so you can propose these things again, in your early case management. That's when maybe you have the best chance of cooperation from opposing counsel, and you haven't dug into any positions where that's going to make agreement on things like this more difficult. So think about these things at the very beginning. One other claim construction issue that, starting with Judge Connolly, this has now gone out to other Delaware judges as well. It's sort of percolating through. More and more judges seem to be ordering, or will appreciate it if you suggest it, a structure of the briefs where instead of the briefs being filed, opening brief, responsive brief, reply brief, surreply brief, you serve them, and then on a claim term by claim term basis, you stitch it together so that what the judge gets is one enormous brief that has all of the positions for all of the terms in the order that makes sense. So that's something that Judge Connolly started in Delaware, and that's being um, uh, that's spreading through judges. I think judges appreciate that. Um, all right, I'm gonna look at we've got just about 5 minutes left, and so making a note to myself. Um, I want to talk about two additional things before we wrap up, and then I'm just going to highlight what the topics are that we didn't quite make it to. Um, I want to talk about Rule 12C, which is, I think, one of my favorite rules. Motion for judgment on the pleadings. So this is a lot like 12B6, but you can bring it anytime before trial. And what 12C does for you, a very standard way of using Rule 12C in patent litigation, is for subject matter eligibility. So for an Alice challenge, a 101 challenge. If you have made that challenge at the pleading stage in a 12B6, and you have lost it because we often lose those very early motions because judges feel we lose them without prejudice, but the judges, understandably, given a lot of the guidance in a lot of case law, say, you know what, for this case, I think we need claims construction. So 12C, a very standard use of it in patent infringement cases, is after you get a claim construction ruling, you can, before summary judgments, you can try again on your 101 motion. Here is where I think we don't think about that 12C often enough is same time period after claim construction, but do we go back and try a non-infringement 12C motion? So this would be at the 12B time frame, it would be an Iqbal Twombly motion that says there is no plausible infringement of this patent claim. Under Iqbal Twombly, you can win that case or that argument early on. It's hard though. But after your claim construction, do you have an opportunity? You can make that same exact argument, but under 12C. The last subject or the last sort of procedural thing to have in your pocket that I think we need to spend a lot of thoughtful time with is what to do with bad infringement contentions. So infringement contentions are required, any district that has patent local rules that are very well built out, they require the patentee to do infringement contentions. And the accused infringer to do invalidity contentions. Infringement contentions are generally early in a case, and often they do not tell you very much. And then you need to decide what to do with those. In some districts, the right thing to do is to push for better infringement contentions, but that is not always the right thing to do. Sometimes the right thing to do is to let the patentee have their bad infringement contentions. And then later in the case, when they want to make them better, it's too late. But that is a play that only works in certain districts where the judges and the rules take those infringement contentions quite seriously. The Northern District of California is one of those places. So a short war story, we had a case where there were sort of two different groups of accused products. Only one of the groups showed up in the infringement contentions. Much later in the case, the patentee tried to get the second group of products into the case, and we were able to strike those based on the fact that they didn't show up in their infringement contentions, and it was the patentee had all of the information that they needed in order to make those assertions on the second group of products. So we were able to basically halve the size of the case through a procedural mechanism in the patent local rules. I am going to highlight in my last minute just a number of other things to be thinking about when you do summary judgments and how you do summary judgments. That is something that you always want to be thinking about in this case management view of litigation. Willful infringement is something that in patent cases you need to think carefully about. Pretrial and trial. This is a place where you need to be organized, and your daily housekeeping in a trial. One of my colleagues says it's, trial by post-it note. The person who has control over what are the disputes in daily housekeeping in a trial can really shape what an individual trial day looks like, and that can be a good opportunity. The bonus topic that I mentioned at the beginning that we are not going to be getting to is 28 USC 1782. If you have clients who have litigation outside the United States, learn what this is. It's something that we can all we can all offer to our clients as an opportunity for their litigation outside the United States. I am not seeing any questions in the Q&A, but I'm happy to stay for a few minutes if there are any questions.
I do have a question or a couple questions within the help desk here that I've found. Since TC Heartland, what venue argument do you think defense counsel are still underutilizing?
I think that plaintiffs are doing, they're not going out on a limb quite as much as they used to on venue arguments. But I think you can, this Apple case, I think, was a good example of, I think it would have been easy for Apple to say, well, we have Apple shops now. And although they're not Apple stores, it seems Best Buy and Target, those are sure those certainly are established and regularly regular and established places of business where they are doing Apple work. I think there was, so there was 6 months of discovery that was done on that. And the ultimate ruling was that there was not venue. So don't give up even in the Eastern District of Texas. I think there are a lot of people that do give up, but you don't need to. There's the chance to win that. I'm seeing another question. How do you think about Rule 12C versus summary judgment? So Rule 12C and summary judgment can be the same, and 12C motions can be converted into summary judgment motions if the judge determines that it is in fact a Rule 56 motion and not a Rule 12C motion. The advantage of a 12C motion is that if you can frame your dispute as being completely on the pleadings, which you can do in the Iqbal for non-infringement in this Iqbal Twombly kind of way, it means that you don't have to go through the end of fact discovery, and you don't have to go all the way through expert discovery before the case is sort of ready for summary judgment. So it's an opportunity to close out the case much earlier if you've got a really strong non-infringement position driven by the claim construction ruling.
I have another one. For attorneys litigating in districts without patent local rules, which portions of the Northern District of California or Delaware rules would you recommend borrowing first?
The contentions, and especially in the Northern District of California, those contention rules are they're well developed. The law on them is well developed, and so those rules, I think, have a lot of power behind them. If you can persuade the court and opposing counsel to adopt those rules, I think you then have a good argument that the case law behind those rules and how those rules are going to be enforced also comes with them, and that can be very helpful. I would not, the damages contentions rules, which are relatively new additions in the Northern District of California, haven't been particularly useful. So I would not necessarily sweep those in, but the contentions rules are very good. And I like the Northern District of Illinois rules on how claim construction is structured.
Do you expect state bad faith patent assertion statutes to have broader practical significance, or will they remain relatively niche tools?
My guess is that we're gonna start seeing more of them being used, because we have some of our other tools are not as useful now. Our IPR and now our EPR tools are not as useful now. I think it's something, and with the Micron case, which I think is something that the Longhorn Micron case got a lot of press. The Rothschild case in Washington got some press. I think it's going to cause people to think about them and use them more often. We'll see. I've been wrong before, but that's my prediction.
All right, let's see. I do have something also regarding, I guess, in light of cases like Valve and Micron, when should defendants seriously consider asserting these state law remedies?
So I think you look at them at the very beginning. Especially if you are getting a demand from that sort of causes that spidey sense to go off. Like this isn't a good faith assertion for whatever reason, whether it's a technical reason, or whether it's because of the nature of the lawyer that is asserting sending you the letter or asserting the complaint, or the particular patent holder. The problem is, one of the problems is, for any of these non-practicing entities, these entities that, bring hundreds and hundreds of cases and are making demands of very small dollar numbers. You have to decide, is it worth the expense of litigating a bad faith patent assertion, counterclaim or independent claim, if you can just settle the case for $20,000. So you need to decide where sort of the principle of the thing, how valuable that is. But I think you think about it early on. Now, as an independent case, you're not limited. So you can, I think another time to look at it is if you get a case disposed of, early and with a really strong opinion. That's another time where you can think about it and say this was a bad faith patent assertion. And one of the things that is considered, and is it bad faith, is what was the result in what has been the result in litigation. So that's another time that you can consider it. And again, it can be useful in sort of pushing a settlement or in pushing a walk away, by having that as a threat or a pending motion, a pending issue.
Alrighty, perfect. So it looks like that was all I had in the help desk today. This concludes today's presentation. Thank you so much again, Karen, for an excellent presentation today. And thank you so much to our audience for joining us. Have a great day, everybody.
Thank you.